शुभ्रवस्त्रामृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतं शङ्करं प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा
As quoted by Theodore Roosevelt, no man is above the law, and no man is below it. Nor do we ask any man's permission when we ask him to obey it. Obedience to the law is demanded as a right, not asked as a favor. Very pleasant good afternoon, everyone. All the dignitaries as well as the participants. This is Ayushi Sharma, and it's my pleasant duty to bid you all a genuine welcome on the behalf of Career Point University, Kota, at this insightful session on the subject Reasonable Restrictions on Fundamental Right, with special reference to freedom of speech and expression. As we all know, this webinar is organized to commemorate the Constitution Day 26 November, which has its own importance in the history of independent India, as in the year 1949, Constitution of India was adopted, which came into effect on 26 January 1950. Therefore, making the dawn of a new era to acknowledge the contribution of the framers of the Constitution, let's start the event by reading the preamble of the Constitution, which is the basis of the Constitution. Let's start. We, the people of India, I'll read the preamble of the Constitution as well. We, the people of India, having solemnly resolved to constitute India in sovereign, socialist, secular, democratic, public, and to secure to all liberty of thoughts, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, ensuring dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, 26th of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Now with this, I would like to welcome all the dignitaries. I would like to welcome and express my gratitude towards Dr. Neetu Naval Ma'am, Dean of Law Department, Dr. Gurudat Kakka Sir, Pro Vice Chancellor of University, Ms. Mitlesh Malvia Ma'am, Head of the Department, and all the faculty members for organizing this enlightening session on this crucial topic of judgment writing. I would like to graciously welcome and thank our eminent speaker, Dr. Lalit Mehra Sir, retired IAS 1984 batch, Rajasthan cadre. He served Government of India for more than 4 years and Government of Rajasthan for more than 32 years. Thank you so much, sir, for accepting our invitation and bring our event with your presence. Now, I would like to highlight the purpose of our webinar. As we all know that constitution is the basis of a law and preamble itself highlights the objective of our webinar. As it states, the objective of a webinar or of a constitution is to provide a better way of life to all of its citizens by ensuring justice, whether it is social, economic, or political, liberty of thoughts, expression, belief, faith, and worship to all the citizens, equality of status as well as of opportunities to all, and to promote among them all the fraternity, which assure the dignity of the individual and unity and integrity of the nation. These are the rights that our preamble itself provides to all the citizens of India, as people are the itself source of the constitution. With this, before starting the webinar, I would like to call Dr. Neetu Naval ma'am, Dr. Dean of Law Department, to welcome our guest. Over to you, ma'am. Ma'am, please unmute yourself. We are not able to hear you. You are not audible actually. Maybe there is some network issue. So before starting, I will highlight the instructions of our webinar. Please note, before we go further, I want to review the functionalities of the webinar. First, please mute your microphone to avoid the background noises that may distract you from listening to the webinar. Throughout the session, someone is managing the functionalities of chat. So ask your questions in the chat box and same will be answered after the webinar. Regarding e-certificate, the link for feedback form will be given at the end of the session after questionnaire session. For the certificate, please make sure that you all fill the feedback form and opt for the certificate. Now, I would like to call Dr. Neetu Naval ma'am, Dean of Law Department, to welcome our guest.
Yes. Very good afternoon
Over to
and
you, ma'am.
of the day. Hello. A warm welcome and regards to our today's dignity guest, Dr. Lalit Mehra sir. Very first, on behalf of Career Point University and representative of School of Legal Studies and Government, felicitate to our eminent speaker, Dr. Lalit Mehra sir. Today we are organizing an expert lecture on the 71st anniversary of Constitution of India. As we know, the Constitution of India is the supreme law of India. So today we are celebrating this occasion by listening the views of well-known personality of Dr. Lalit Mehra sir on the topic of fundamental rights with reference of freedom of speech and expressions. But before his lecture, I would like to share a wonderful administrative journey of Dr. Lalit Mehra sir. It's a prideful moment for us that we are here with the high profile officer. uh, he is retired IS officer, 1984 batch, Rajasthan cadre. From 1984 to 2016, Dr. Mehra sir posted in near about 28-29 departments. As an administrative officer, he was posted as secretary, principal secretary, chairman, managing director, project director, director, chief executive director, chief executive officer, commissioner, secretary of government departments, vice chancellor, collector of Nagaur, collector of Bikaner, collector of Hanumangarh. So he served Rajasthan stayed in various capacities and various departments for more than 32 years and served Government of India for more than 4 years. Now Dr. Mehra sir involved in active politics. He has number of feathers of academic degree like BSc, MA Public Administration and Economics, Diploma in Management, PGDIM, PGDFM, MBA Finance, MBA Green Business, LLB, LLM, PhD in Commerce, and pursuing PhD in Law. He is awarded 63 certificates from foreign universities on various subjects like relating to finance, management, business, intercoastal relations. We are very grateful to Dr. Mehra sir for accepting our invitation in very kind way. We are thankful and honored to this glorified dignity, Dr. Lalit Mehra sir, to being with us. Thank you so much to all the faculties, CP faculties, management, and students, and all the participants for your excellent response and registration for this online legal expert lecture. Thank you. Thank you so much.
Thank you so much, ma'am. In the words of Robin Morgan, knowledge is power, information is power. The secreting or hoarding of knowledge or information may be an act of tyranny camouflaged as humility. With this quote, I would like to call Honorable Sir Dr. Lalit Mehra to enlighten us with their knowledge and help us to reach that path. Over to you, sir.
Unmute,
Sir,
unmute.
your voice is not audible. Please unmute yourself. Sir, your voice is not audible actually. Can you please unmute yourself? I think there is some network issues. Let's wait for 2 to 3 minutes.
Now I am audible. Arushi?
Yes, sir.
Is it audible now? Now voice is reaching?
Yes, sir. Yes, sir. Audible, sir. Okay, sir.
Oh. It's a matter of pleasure for me to associate with you people, learned people in the field of academics and professionalism, and particularly in the subject of law. I have been associated with the administration, but all through, obviously, when a question of law emerged, the word, another word, the bigger word, constitution was there. The Indian constitution is soul of our system. The Indian constitution provides many freedoms which are very fundamental to the life of the people in India. The right to freedom is one of the most fundamental and basic freedom which is available and enshrined in the Indian constitution. The right to freedom ensures right for people to lead a life with dignity. Freedom is a state under which people can speak, act, and share their opinions and imagination to other participants or other receivers. One individual under this freedom can think, feel, act, and impart or share or receive information so as to propagate one's active life in the social and political life of the country. The freedom of speech and expression is one of the most important one, because if that is not available, the democracy in our country cannot develop and progress. There cannot be any sign of democracy if this freedom of speech and expression is made available as a matter of right, as a matter of fundamental right. As you can say, part 3 of the Indian Constitution provides fundamental rights. Fundamental rights are very varied. Where originally there were 7 in number, now they are 6, because right to property was taken away long back because it was not desired, and with the verdict of the apex court, right to property was not treated as fundamental right. So Article 19, 20, 21A and 22 provide for right to freedom of speech and expression, which are very essential and granted to every citizen of this country, so as to contribute actively, progressively and productively in the growth process of this country. The total these freedoms which are given in the Indian Constitution are 6 in number. I must share with you the freedom of speech and expression, freedom to assemble peacefully without any arms, freedom to form associations or unions, freedom to move freely throughout India, freedom to reside and settle in any part of the country, freedom to practice any profession or to carry on any business, occupation or trade. So far as constitutional provision with regard to the fundamental rights is concerned, the similar situation is there, because freedom of speech and expression is one of the fundamental rights, as the particular situation so far as the fundamental right with regard to freedom of speech and expression is concerned. All these qualities and references apply to all the remaining fundamental rights also as enshrined in the Indian Constitution. The different fundamental rights which are available in the Indian Constitution, the freedom of speech and expression provided under Article 19(1)(a) of the Constitution is such privilege which without such privilege one cannot think, feel, act and share the information or the viewpoints which one frames after having experience with the interaction process. Freedom of speech and expression enables an individual to openly share his or her views with some reasonable restrictions. It is an essential right in democratic system, because if this right is not made available, democracy cannot work efficiently. It is an essential right in democracy granted by Article 19(1)(a) of the Constitution. If upholds, as you can see, the liberty of thought and expression principle which has been taken provided in the preamble to the Constitution. Freedom of speech and expression grants Indian citizens the right to communicate their thoughts and views without apprehension by means of words, written or oral, spoken, pictures or some other visual or communicable representations such as gestures and signs. It contains the freedom to propagate one's opinions and opportunity to publish other people's view as well. Free expression cannot be equated or confused with a license to make accusation against the judiciary that are unfounded and irresponsible. Therefore, the right to speech and expression is not an absolute right. It has some restrictions. State can enforce reasonable restriction under Article 19(2) of the Constitution. The reasonable restrictions are total 8 in number. Originally, there were only 6 restrictions in the original Indian Constitution. I would like to share with you these 8 reasonable restrictions which are provided under Article 19(2). Defamation. Defamation refers to statements which injures a man's reputation. Anything which is said or shown by gestures or spoken words or just bodily signs, and that injures a person's reputation, that will be rated as defamation of the person against whom that signs or gestures have been made. Contempt of court. Restriction may be instituted on the freedom of speech and expression if it surpasses the reasonable limit and amounts to contempt of court. Section 2 of the Indian Contempt of Court Act provides for various provisions with regard to the contempt of court as to what will amount to contempt of court and in what manner the adjudication with regard to contempt of court, whether it has taken place or not, the competent court will take a look into the aspect. Decency or morality. Under Indian Penal Code, Section 292 and 294 provide the situation where freedom of speech and expression is limited in the interest of dignity and morality. Security of the state. Under Article 19(2), the limitations on the freedom of speech and expression can be placed in the context of state security. Friendly relations with other states. The intention behind this provision is to prevent unrestricted malicious publicity against a friendly foreign state that can disrupt India's good ties with that state. Insight to an offense. This provision was added in 1951 First Amendment Act to the Constitution. Freedom of speech and expression cannot provide citizens with a privilege to incite people to commit offenses. Next one is sedition. Sedition supports all those activities, whether through words or writing, determined to disrupt the state's tranquility and drive misguided individuals to subvert the government. Subverting the tranquility that is regulated by the government as a normal situation. So subversion of the government, established government, will be rated as sedition. Public order. This was again instituted by the First Amendment to the Constitution, and which this one perturbed peace, public peace, tranquility, and perturbs public order. In the interest of public order, involves not only utterances which are made explicitly, but which appear to contribute to disorder are also included. In addition to these 8 limitations, the right to freedom of speech and expression under Article 19 of the Indian Constitution is revoked during the time of national emergency. When national emergency is working under by the order of the President of India, during such time, the freedoms are restricted to a major extent. All the fundamental rights also are put in under suspension by the order of the President of India during the time of the national emergency, during the operation of the national emergency, except the right to life. The right to life cannot be taken away under any kind of the situation, whether normal or some land order problem is going on or national emergency situation. It's totally different, as you can understand. With regard to right to speech and expression, right to information is another aspect of the right to freedom, right and freedom of speech and expression. Right to know, right to information are other facets of freedom of speech. The right to know, to receive, or to impart information has been recognized within the right to freedom of speech and expression. A citizen has a fundamental right to use the best means of imparting and receiving information, and as such, an access to telecast for the purpose. The right to know, however, yet not extended to the extent of invalidating the provision as provided under Section 5 of the Official Secrets Act 1921, which prohibits disclosure of certain official documents. Even Right to Information Act 2005, which specially talks about people's right to ask information from government official, also prohibits disclosure of some official documents under Section 8(2) of the Act of 2005. These exceptions are generally the grounds of reasonable restrictions over freedom of speech and expression under Article 19(1) of the Constitution. One can conclude that the right to uh, information is a small limb of the right to speech and expression. Right to speech and expression is overall the highest level of the right available to a citizen, and this is right to information is a smaller limb of the same right. The grounds of restrictions are have been also made clear in the Constitution. It is necessary to maintain and preserve freedom of speech and expression in a democracy. So also it is necessary to place some restriction on this freedom for the maintenance of social order, because no freedom can be absolute or completely unrestricted. Article 19(2) of the Constitution, the state may make a law imposing reasonable restrictions on the exercise of the right to freedom of speech and expression in the interest of public on the grounds which are made available under Clause 2 of Article 19. The Indian Constitution contains the ground on which restriction on the freedom of speech and expression can be imposed. The first one is security of state is of vital importance. The government must have the power to impose reasonable restrictions on the on this activity. So, because security of the state, maintenance of security of state is of utmost importance for the government. The law and order and public order are to be maintained, and no government, no democratic system can afford the security of the state to be at risk. Friendly relations with the foreign states. In the present global world, a country has to maintain good and friendly relations with the other countries, sometimes which has to be potential to affect such a relationship, which shall be checked by the government. Such activities which affect the good relationship with the friendly relations throughout this world are to be taken care of, because if reasonable restrictions are not imposed on such free use of then any malicious propaganda or the mission can disturb the good relations with the other countries and jeopardize the status going on with regard to the relations. Public order. This ground was added by the Constitution First Amendment Act. Public order is an expression of wide connotation and signifies the state of tranquility which prevails among the members of political society as a result of internal regulation enforced by the government which they have established. It is pertinent to look into meaning of the word public order. Public order is something more than ordinary maintenance of law and order. Public order is synonymous with public peace, public safety, and tranquility. Anything that disturbs public tranquility or public peace disturbs public order. Thus, communal disturbances and strikes promoted with the sole object of accusing unrest among workmen are offenses against public order. Public order implies absence of violence and orderly state in the affairs of of which citizen can particularly pursue with normal avocation of life. Public order, that kind of public order has to be maintained where anyone with his or her choice can pursue any profession. Public order also includes public safety. Thus, creating internal disorder or rebellion would also affect public order and public safety. But mere criticism of government does not necessarily disturb public order. The word "in the interest of public order" includes not only such utterances as are directly intended to lead to disorder, but also that have the tendency to lead the disorder. Thus, a law punishing utterances made with the deliberate intention to hurt the religious feelings of any class of person is valid because it imposes a restriction on the right of free speech in the interest of public order. Since such speech or writing has the tendency to create public disorder, even in some cases, activities may not actually lead to a breach of peace, but must be reasonable. There must be reasonable and proper nexus between relationship between the restrictions and the achievements of the restrictions. Decency and morality. The way to express something or to say something should be a decent one. It should not affect the morality of society adversely. Our constitution has taken care of this view and inserted decency and morality as a ground. The words morality and decency are words of wide meaning. Section 292 to 294 of the Indian Penal Code provide instances of restrictions on the freedom of speech and expression in the interest of decency and morality. This section prohibits the sale or distribution or exhibition of obscene words in the public places. No fixed standard so far is laid down till now what is moral and what is immoral. In this, the standard of morality varies from time to time and from place to place, and obviously, in the past we have seen it depends on the judgment of the judge who is sitting over such issue to adjudicate on such matter. Contempt of court in a democratic country, judiciary plays a very important role. In such situation, it becomes essential to respect such an institution and its order. The restriction on the freedom of speech can be imposed if it exceeds the reasonable and fair limit, and which will amount to contempt of court. According to Section 2 contempt of court, it may be either civil contempt or criminal contempt. But now Indian contempt law was amended in 2006 to make truth a defense. Defamation, one's freedom may be of any type, must not affect the reputation or status of another person. A person is known by his reputation more than his or her wealth or anything else. Constitution considers it is ground to put restriction on freedom of speech. Basically, a statement which injures a man's reputation amounts to defamation. Defamation consists in exposing a man to hatred, ridicule, contempt, etc. The civil law relating to defamation is still uncodified in India and is subject to exceptions. Incitement to an offense. This ground was again added by the First Amendment Act in 1951. Obviously, freedom of speech and expression cannot confer a right to incite people to commit offenses. The word offense is defined any act or omission made punishable by law for the time being in force. Sovereignty and integrity of India. To maintain the sovereignty and integrity of India is the prime duty of the government. Taking into account freedom of speech and expression can be restricted so as to permit anyone to challenge sovereignty or to permit anyone to preach something which will result in threat to integrity of this country. From this analysis, it is evident that the ground contained in Article 19.2 show that they are all concerned with the national interest or the social interest, the interest of the society. The first set of grounds, sovereignty and integrity of India, security of the state, friendly relations with foreign states and public order are all grounds referable to national interest. Whereas second set of grounds, decency, morality, contempt of court, defamation, and incitement to an offense, all are concerned with the interest of the society at large in peacetime. Conclusion. Expression through speech is one of the basic guarantees provided by civil society. However, in modern times, right to freedom of speech and expression is not limited to express one's own view through words, but it also includes circulating one's views in writing or through audio-visual instrumentalities, through advertisement and through any other communication channel which is available. It is also it also comprises right to information, freedom of press, etc. It is a right to express and self-realization. There are some landmark judgments also with regard to freedom of speech. Freedom of speech is also part of freedom of speech and expression. Freedom of press. Freedom of press is essential to the freedom of expression, which forms the backbone of political freedom and genuine functioning of this democracy. In Romesh Thapar versus State of Madras, the court affirmed that the enforcement of pre-censorship on a journal constituted an infringement on the freedom of press, which is an essential part of Article 19(1)(a), which provides freedom of speech and expression. The judgment added that free political dialogue is necessary if a democratic government is to work efficiently and properly. Indian Express newspaper versus Union of India, the court confirmed that freedom of press plays a very important role for the proper functioning of democracy, driving its roots from Article 19(1)(a), and that it is the duty of the court to uphold freedom of the press. Bennett, Coleman and Company of Union of India, according to Supreme Court, in this case, constant of the permissible number of pages, that if a restriction is imposed on any newspaper, that this much number of pages only you can publish as in your daily newspaper, like that number of pages in the newspaper was found to be in violation of Article 19(1)(a) and not reasonable restriction under 19(2). Prabhu Dutt versus Union of India, the right to know about the news and details related to the government working, day-to-day government working, is included in the freedom of press. Right to broadcast, the introduction of with the technology, obviously there are various means with which we can interact. The courts have acknowledged the modern aspects of freedom of speech and expression, the right to broadcast and advertising. In Odyssey Communications Private Limited versus Lok Vidyan Sanghtana, Supreme Court ruled that the privilege of a person to display film on the Doordarshan state channel is part of the freedom of speech and expression as provided under Article 19(1)(a). The petitioner challenged the displaying of the serial known as Honi Unhoni on Doordarshan on the basis that it prompted the audience to believe in superstition and blind faith. The claim was rejected as the plaintiff became unsuccessful in showing evidence of detriment caused to the public. Supreme Court has also held that freedom to transmit and acquire information pursuant to Article 19(1)(2) is a necessary right. It is to guarantee that people are aware and that one-sided information or misinformation will not render democracy a farce. Dinesh Trivedi, MP, and others versus Union of India, Supreme Court affirmed that in a modern democratic society governed by the Constitution, it is obvious that citizens are entitled to know about the affairs of the government which they elect. That we elect the government, so we have the basic right, fundamental right to ask what they are doing. The process has been provided under Right to Information Act 2005. So this has been affirmed by the Apex Court in case of Dinesh Trivedi, MP, and others versus Union of India. In right to criticize, Rangarajan versus Jagjivan Ram, it was affirmed that it is appropriate to form and convey an opinion in a manner which does not cause defamation to other individual to whom such critique is addressed and is secured under the freedom of speech and expression. The decision added that democracy calls for open discussion and policy criticism. Right to expression is beyond national boundaries. In case of Maneka Gandhi versus Union of India, Supreme Court confirmed that freedom of speech and expression was not limited to geographical limitations or boundaries, and claimed that Article 19(1)(a) encompasses both the right to speak and freedom to express in India or also in abroad. right to refuse to speak or right to silence. In a case of Bijoy Emmanuel versus State of Kerala, the school dismissed 3 students for denial to sing national anthem. Yet when the national anthem was playing, the children took a stand in respect. The legality of the students' expulsion was questioned at the Kerala High Court, and they confirmed the students' dismissal on the basis that singing the national anthem was their fundamental duty. Yet, on an appeal brought before the Supreme Court against the order of the Kerala High Court, the Supreme Court held that the students had committed no offense under the Prevention of Insults to the National Honors Act of 1971, and further stated that dismissal of school children for not singing the national anthem created a violation of their rights to freedom of expression. Democratic government provide the people with one or most of the fundamental rights, that is freedom of speech and expression. Indian courts have defined the meaning and content of Article 19(1)(a) broadly, rendering it subject only to the limitation allowed under Article 19(2). Besides the favor, there is also criticism about the application of the freedom of expression. Freedom of expression is a fundamental human right which needs to be upheld in democratic societies. Yet there is a worrying global trend among governments that unjustifiably restricts freedom of speech by targeting journalists, protesters, and other people who are considered to be dissenting from government views. Misuse of the restrictions. The question arises, is there any misuse of restrictions? The freedom of speech and expression is subject to restrictions which are deemed to be reasonable by the government. The government of India has framed various penal laws to ensure that the right is not used against the interest of the state or its citizens. For Section 153A of the IPC criminalizes promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. Section 298 also criminalizes uttering words, etc., which deliberately intend to wound the religious feelings of the person. Sedition is a major example of the regulating the freedom of speech. Section 124A of IPC criminalizes any act which instills or intends to instill the feeling of contempt or dissatisfaction towards the government established by law. The act of sedition was criminalized in 1980 by the British government. Section 124A, although an important restriction to maintain peace and harmony throughout the country, is being misused by the political and religious leaders to silence the people who speak against them. The amount of sedition cases lodged have increased drastically during the past 3-4 years. Majority of these cases filed with the purpose of pressurizing the individual as well as the media houses to revoke their statements. Else they would be stuck probably for years under the burden of court proceedings and trials, affecting them both mentally as well as financially. The misuse of restriction on freedom of speech is defamation. The act of defamation is a crime under Section 499 and 500 of Indian Penal Code. However, the term is so broadly defined that any person or entity can claim damages under defamation for the statements published about them. This loophole is exploited usually by huge multinational corporations who do not sue the individuals, such as journalists or environmental activists or even media houses under the charge of defaming. They claim for monetary damages. The big business houses or corporations, they demand that this much of damage has already been inflicted upon their activities. So this claim of monetary damage, which is so immense that it is beyond the capacity of the individuals or the media houses. So Obviously, this will create mental harassment and the financial harassment to the journalist or to the activist. So they would like to withdraw from the scene. Misuse of the right. The right of freedom of speech and expression was incorporated by the drafting committee of the Constitution of India with the aim to ensure that the citizens can express their feelings, views, even though critical in nature, freely and without fear of facing any repercussions for the same. While the right has, for the most part, given freedom to the citizen to provide constructive criticism to other individuals as well as to the state, the right has been abused and exploited mostly by the political and religious leaders across the country. The right is being the right is being used as a shield under which the leaders are instigating and provoking the masses against their counterparts, be it another political party, different religion, or simply another group with a different ideology than their own. The leaders deliver hate speeches against such individuals and communities under the name of exercising their rights, abusing and performing a character assassination in the name of expressing their views on the event or a person. The right of freedom of speech and expression is an integral right of each and every human being and part of the basic fundamental rights provided by our constitution, along with a provision to apply reasonable restriction on the same. However, the right as well as the restriction have been exploited and misused by multiple occasions, ranging from mental and financial harassment through defamation and sedition suits to delivering hate speeches under the name of this free speech. So the question that arises is what can be done? Is it feasible to remove the restrictions or decriminalize sedition and defamation, or should the restrictions be made more stringent to prevent hate speeches and instigation? The constitution must be interpreted in a broad way and not in a narrow one. The court must not be too astute to interpret the language of the constitution in so liberal a sense so as to whittle down the fundamental rights. On the other hand, the court must interpret the constitution in a manner which would enable the citizen to enjoy the fundamental rights in its fullest measure. The legislature cannot disregard or override constitutional provision by employing indirect methods of achieving exactly the same results. The legislature cannot do indirectly what it cannot do directly. It is the substance and the practical result of the act of the state that should be considered rather than its pure legal aspect. The correct approach should be to inquire what is in substance is the loss or injury caused to the person, and not merely what manner and method which was adopted by the state in placing the restrictions. No law or action would state in words the right of the freedom of speech and expression are abridged. Nevertheless, it is the duty of the court to strike down the legislation or the executive action or any administrative action or statutory rule or regulation notification if it causes direct interference with the freedom of speech and expression, notwithstanding that it does not appear to be so on its face. In the garb of distribution of newsprint, the growth and circulation of the newspaper cannot be controlled. In dealing with the complex strands in the web of freedom which make up free speech, the operation and effect of methods by which speech is sought to be restrained must be subject to close analysis and critical judgment in the light of the particular circumstances to which it is applied. Where fundamental rights and freedoms of the individual are being considered, a court must be very cautious before accepting that the views that some particular disregard of the minimal account was there, so it is not a serious matter. So the court will have to be very cautious and make a critical judgment of any submissions made before the Honorable Court. Areas of restrictions and constitutional prerequisites for imposition of restrictions. The first prerequisite or curtailment of freedom of speech and expression is that the restriction imposed must have the authority of some law to support it. Law means a valid law, be it a statute, statutory law, or statutory notification or regulation. It is only thereafter that the question arises whether the restriction imposed are reasonable or permissible. Fundamental rights cannot be restricted by a mere executive order or an administrative instruction or a circular or a resolution without any statutory basis. Orders or regulations or instructions which purport to restrict any fundamental right must have been made in the exercise of the legislative power of the state and not in the exercise of its executive power. Furthermore, not only the law restricting the freedom should be reasonable, but the rules and the orders made on the basis of that law should also be reasonable and fair and transparent. The freedom of press cannot be curtailed, like the freedom to carry on business in the interest of general public. Because action is taken most of the time, restrictions are imposed and put into play, that it is being done. The restrictions are being imposed in the interest of the public at large. If the law is challenged, it is no answer that the restrictions enacted are justifiable under clauses 3 to 6 of Article 19. The only restriction which may be imposed on the rights guaranteed under Article 19 are those which clause 2 of Article 19 permits and no other. The right of freedom of speech cannot be taken away with the object of placing restriction on the business activities of a citizen. If the legislation or the executive action interferes with the freedom of speech, it is no answer that it is a regulation of the business aspect of a newspaper. The object of giving some kind of protection to small or newly started newspapers may be good and desirable, but Article 19(2) does not permit the state on that ground to make inroads in the freedom of the speech which is guaranteed by the Constitution, or the facility which are available and made available to other newspapers. After carrying on unfair practices may be a matter of condemnation, and monopolies may be assumed to be obnoxious and against public interest. Even so, restriction for the above purposes are beyond the scope of 19(2) and are unconstitutional. The word reasonable implies intelligent care. How do we decide that it is reasonable? The intelligent care has to be used, and a very careful analysis has to be made by the decision-taking authority whether this is reasonable or not. The word reasonable implies intelligent care and deliberation, that is the choice of the course which reason dictates. The course which is taken to take a decision on such a situation, the reason must dictate that course. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness. Arbitrarily or excessive restriction which is imposed by any legislative action, that cannot prove and establish the quality of the quality of reasonableness keeping in it. The procedure and the manner of imposition of restriction must also be fair and just. The manner of imposing should also be fair and transparent and objective. No abstract standard or general criterion or pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of the evil sought to be remedied, thereby the disproportion of the imposition, the prevailing conditions at the time should all enter into the adjudication process. Permissible restrictions on any fundamental right, even where they are imposed by duly enacted law, must not be excessive, or in other words, they must not go beyond the necessity to achieve the objective of law under which they are sought to be imposed. The power to impose restriction on fundamental rights is essentially a power to regulate the exercise of this right. In fact, regulation and not extension of that which is so regulated is, generally speaking, the extent to which permissible restriction may go in order to satisfy the test of reasonableness. Laws which take away or abridge the freedom of speech and expression, or which curtail circulation and thereby narrow the scope of dissemination of information, or later their freedom of the press to choose its means of exercising the right or would undermine its independence by driving it to seek government aid, which single out the press for laying upon its excessive and prohibitive burdens, which would restrict the circulation, impose a penalty on its right to choose the instruments for its exercise. It is not the government to determine. It is not for the government to determine which newspaper should grow in page and circulation, number of pages and circulation, the area, geographical circulation, etc. These are not the issues to be decided and taken care of by the government. And the newspaper should grow only circulating in circulation and not in pages. It's not the duty of the government. That circulation may increase, but not in pages. Number of pages is limited. Is also making inroads on the freedom of press and expression, freedom of speech and expression, fixing the number of pages and the geographical circulation area for any particular newspaper is also a restriction which is unconstitutional. Freedom of press entitles newspaper to achieve any volume of circulation. Freedom of speech and expression is not only the volume of circulation, but also the volume of news and views. The question about the quantity of newsprint to be imported is the matter of government policy. Court cannot adjudicate on such policy unless the policy is alleged to be malified. Freedom lies both in circulation and in content. A newsprint policy under the Import and Export Control Act, under the garb of distribution of newsprint, cannot control the growth and circulation of newspapers. A newsprint policy cannot impose restrictions which constrict the newspaper in adjusting their page number and circulation. If the space for advertisement is reduced, it will reduce the earnings of the newspaper concerned. So the earnings would decline, and if the price is raised, that would affect the circulation and thereby impinge on the freedom of speech and expression. The press is, however, not immune from the ordinary form of taxation. There are fiscal policies, various fiscal policy issues with the government of India and the state government, various for support of the government, nor from the application of the general laws relating to the industrial relations. All the laws and rules and regulations and notifications which are issued for keeping in view the developmental economics or the welfare economics or the positive industrial relations, that will apply on the newspaper also. That won't be rated as excessive or arbitrary. A statutory provision which prohibits the commending of any intoxicant. A statutory provision which prohibits the commending of any intoxicant is violative of freedom of speech and expression and is not saved by clause 2 of Article 19. Advertisement is undoubtedly a form of speech. However, it cannot be said that every advertisement is a matter dealing with the freedom of speech, nor can it be said that it is an expression of ideas. Whenever it takes a form of commercial advertisement which has an element of study of commerce, it no longer falls within the concept of freedom of speech, for the object is not propagation of ideas, social, political, or economic, or furtherance of literature or human thought. A trader has not fundamental right under Article 19(1)(a) to commend his wares, especially when they are prohibited drugs, commodity of which the sale is not in the interest of general public, in as much as the commercial activity of commendation of such goods is not within the guarantee of the Article 19(1)(a) at all. The main source of income for the newspaper is from advertisement. Advertisement are not only source of income but also one of the factors for circulation. The loss of advertisements affects the circulation of the newspaper, and a restraint on advertisement would affect the fundamental right under Article 19(1)(a). If the area for advertisement is curtailed, the price of the newspaper will be forced up. It will go up. If that happens, the circulation will inevitably go down and earnings will go down, and earnings will decline. That would directly interfere with the freedom of press. The direct operation of legislation upon fundamental rights forms the real test. It is not the object of the authority making the law, nor the form of action that determines the innovation of the fundamental right. It is the effect of the law. What ultimately the effect is seen as a matter of result of the action taken. It is the effect of law and of the action upon the rights of a citizen which attract the jurisdiction of the court to grant relief. The true test is whether the effect of the imposed action is to take away or abridge the fundamental rights. The effect of the state action taken, however, must be direct and inevitable, and not remote or problematical, and not dependent upon various factors which may or may not come into play. The doctrine of direct and inevitable effect has been described as the doctrine of intended and real effect, or as the test of proximate effect and operation of the statute. The test of object of the legislation, pith and substance as the subject matter, and direct and incidental effect of legislation are irrelevant to the question of infringement of fundamental rights. The restrictions on the fundamental freedom can be placed in terms of clause 2 of Article 19 in the present form was inserted in 1951 and was subsequently amended in 1963 in case of maintaining good relations with the friendly nations. Originally, the constitutional limitation clause of Article 19(2) was not so comprehensive. Earlier, it was not so comprehensive, merely it laid down that nothing shall affect the operation of any existing law or prevent the state from making any law related to libel, slander, defamation, sedition, or any other matter which offends against decency or morality or undermines the security of or tends to overthrow the state. While considering the reasonableness of the restriction, the court has to keep in mind the directive principles of state policy. Restrictions must not be arbitrary or of any excessive nature so as to go beyond the requirement of the interest of the general public. In order to judge the reasonableness of the restrictions, no abstract or general pattern or a fixed principle can be laid down so as to be of universal application which can be used, picked up and used by anybody at any stage of time. And the same will vary from, but as earlier also I said, the restrictions, the pattern will depend on place to place and case to case with regard to changing conditions, values of human life, social philosophy of the constitution, prevailing conditions and surrounding circumstances. A just balance has to be struck between the restriction imposed and the social control envisaged by clause 6 of Article 19 of the Constitution. Prevailing social values as also social needs which are intended to be satisfied. There must be a direct and proximate nexus or a reasonable connection between the restrictions and the object sought to be achieved. If there is a direct nexus between the restrictions and the object of the act, then a strong presumption in favor of the constitutionality of the act will naturally arise. In applying the test of reasonableness, the court has to consider the question in the background of the facts and circumstances under which the order was made, taking into account the nature of the evil sought to be remedied by such law. The ratio of the harm caused to individual citizens by the proposed remedy to the beneficial effect reasonably expected to result to the general public. It will be It will be necessary to consider whether the restraints caused by the law is more than necessary in the interest of the general public. The Supreme Court further explained the interpretation of the expression reasonable restriction that there should be a direct connection between the action taken and the result sought for. The minimum possible injury is to be inflicted upon while taking action under the restrictions provided already. The expression reasonable restriction has introduced the doctrine of judicial review. The Supreme Court laid down the determination by the legislature of what constitutes a reasonable restriction is not final or conclusive. It is subject to the supervision of the court. In the matter of fundamental right, the Supreme Court watches and guards the rights guaranteed by the Constitution, and in exercising its function, it has the power to set aside an act of the legislature if it is in violation of the freedom guaranteed by the Constitution. The court also observed legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness. And unless it strikes a proper balance between the freedom guaranteed under Article 19(1)(a) and the social control permitted by Clause 6 of Article 19, it must be held to be wanting in that quality. So I think I have taken my time. Thank you.
Thank you so much, sir, for your intuitive words and for gracing our event. Now, sir, shall we can go for the query session? There are few and certain questions asked by the students. Sir, can we ask query?
Oh, obviously, you can.
Okay, so let's move forward the query session. There are certain questions in the Q&A box, but due to the limited time, we would be able to ask few questions. So the first question is whether the telephonic taping is a violation of freedom of speech and expression.
As I said, there are two categories of the situations which demand restrictions. There is sovereignty and security of the state and public order, and second are normal issues. In the normal sense, we can say until unless there are pressing needs to go for tapping of the telephone talks, it's not constitutional. Am I clear? Until unless sovereignty and integrity and security of the state or public order, the situation so demand that it is not advisable not to go for this activity so as to control the problem which are going on and the problem suitors which are active. Taping of telephone calls is not possible, cannot be done, and it is unconstitutional. There are some provisions in the Indian Telephone Act. There are some provisions in the Indian Telephone Act which provide for, in these particular situations, with the permission of the competent authority in the state government or the government of India, the telephone talks can be tapped.
Thank you so much. Now let's move forward to the next question. Next question is commercial advertisement are part of freedom of speech and expression or they violate it?
Actually, until unless commercial It's very slippery question. Commercial advertisement, obviously, it's the income of the newspaper, commercial. If it is an expression of one's ideas and opinions, thinking process, etc., it not a problem. But if it is commendation, as I pointed out when I was talking with you people, commendation of any wares by the manufacturer, by the trader, and the wares are in the category of intoxicants or the goods which cannot be permitted to be sold, then the commercial advertisement relating to those situations cannot be permitted, and such commercial advertisement are against the right to speech and expression.
Thank you so much, sir. I hope students are satisfied. Thank you so much, sir. Now I would like to call Ms. Mitlesh Malviya ma'am, head of the department, to present a vote of thanks.
Thank you, Ayushi. And I'm very grateful, thanks to other dignitaries, on behalf of School of Legal Studies and Governance at Career Point University. I give a really heartfelt vote of thanks to our Chief Guest, Dr. Lalit Mehra sir, who spent his busiest time gracing the occasion. Today we had the opportunity to hear your thoughts, and this is definitely encouraging us in our future event. And I started some quotation from Bergen Evans. Freedom of speech and freedom of action are meaningless without freedom to think, and there is no freedom of thought without doubt. Freedom cannot be described in simple words because this term contains many deep meaning. Freedom is the power or right to act, speak, or think as one wants without limitation. And the points where Dr. Lalit Mehra sir us about the primary purpose of Article 19 is to protect certain primary act regarding freedom of speech. According to the article, every citizen has the right of freedom of speech and expression, assemble peacefully and without arms from association or union, move freely throughout the country, reside and settle in any part of India, and practice and profession or carry on in occupation. And in fact, the right of information, right to praise, right to speech, many rights are emergence and fundamental rights under this article, and the prerequisite from enjoying the freedom of speech and expression in access to knowledge and information. And Lalit sir told us about the restriction on the Article 19 and freedom of speech, like sovereignty, integrity, and security of India. The state can enact any law that is impose reasonable restriction on the exercise of the right mentioned in Article 19. We and the other student and participant have got a deep understanding and insight and about freedom of speech in this session. We acknowledge Honorable Dr. Lalit sir with a token of appreciation in the form of virtual certificate. Please kindly accept. Please kindly accept with our best regards.
Thank you.
Please sir, accept the certificate. Thank you,
It's
sir.
okay. Thank you. Thank you.
I would also like to thanks to Pro Vice Chancellor Sir Dr. Gurudat Kakkar sir for gracing the session by valuable words and presence. And I would like to say thanks to all attendees present in this expert lecture, and we hope to see you all again for such informative session. Thank you, sir. Thank you all dignitaries and participants. Thank you to you.
Thank you so much, ma'am, for the vulnerable vote of thanks. Now, we would like to end the session.